on then maybe to what we could perhaps call quasi-judicial processes. Tell me about early neutral evaluation. What's that, and when does that happen?
Early neutral evaluation occurs when the parties, probably one of the parties will propose to the other that rather than taking the matter to a court for a decision, they'll appoint a neutral third party to be briefed by both parties on the dispute and then to make an evaluation. So it's early, it's before process starts, it's neutral, it's by an independent third party neutral, and it's an evaluation of the prospects of success of the case. It can be binding, in which case the parties have agreed whether they win or lose as a consequence of that decision or that evaluation, they'll just stick with it and they'll have to recognise it. So it'll be contractually enforceable. Alternatively, it can be non-binding, in which case it is it only has persuasive value. It can't be used as evidence, but it can obviously be very important, have quite a significant impact on the party who's found out that the evaluation's turned out against them, and will, even if it's non-binding, will often result in there being a settlement along the lines of the evaluation.
That was going to be my next question, is what is the next option then if the evaluation is not binding?
Well, if it's not binding, and I've seen this happen, the party who's lost will either throw their toys out of the pram and say, well, the evaluator's got it completely wrong for this, that, and the other reason, and invite them to reconsider and try and present new evidence, and just kicks off into a bit of a fight at that point. Alternatively, they may be quite accepting of it, and in my experience, the early neutral evaluation has worked where there is a continuing relationship, or an issue where a company hasn't wanted to make a decision themselves that they were wrong, and they're prepared to accept a third party's opinion.
Okay.
And so they'll be accepting of it and proceed accordingly.
And who is the evaluator? What sort of a person is that?
Well, they're going to be fulfilling a quasi-judicial function, essentially. So parties will typically appoint a lawyer.
Okay.
Not always, depends on the nature of the dispute, but a lawyer, or somebody certainly who's versed in the issues which are in dispute. If it's a legal dispute, it's going to be a lawyer probably. Sometimes they're retired judges, maybe they're senior barristers, maybe they're just senior solicitors. It will depend on the nature of the dispute as to who you particularly choose. So if it's a construction dispute, then you'll be looking for somebody with knowledge and experience in that field. If the issue is purely related to engineering, then you might ask an independent expert engineer to give you that opinion.
Okay, so it sounds like you need that person to have extensive subject matter knowledge and be able to apply the law to a set of facts. Is that right?
Yes, subject matter knowledge, personally, I think is important when you appoint any neutral. Okay. Not everybody agrees with that, I would add. But certainly if you're entrusting an evaluation of a complex situation to a third party, you're pretty well going to need them to show some real expertise in that subject matter.
And is early neutral evaluation available for all types of disputes?
Yes. It, as with most forms of ADR, it's only available if the parties will agree to it. And just as they can agree to mediate their dispute or conciliate their dispute or whatever else it may be, they can agree to have an early neutral evaluation. Anticipating your next question, in my experience, early neutral evaluation isn't used a huge amount. And one of the problems with it is it typically because it's early in the
Yeah.
process, the parties haven't really investigated fully the circumstances.
Okay.
And there's often an anxiety that, well, we haven't had access to the other party's documents
Of course.
or evidence of witnesses as to what's happened and why we're in this situation, or we haven't had the necessary experts look at the situation. So there's often a reluctance to agree to this early evaluation.
Okay. So what would the big benefit then, or what would drive somebody to say, look, let's get an evaluator in here and get this sorted at this early stage, notwithstanding the fact that we don't have as much information as we might do 6 months down the road?
Well, I think the answer to that is that it particularly works well if there's purely a legal issue, maybe an interpretation of a contract. What does this contract mean? So it's quite a simple, narrow point, which isn't dependent upon a whole host of evidence about who did what, when, and where. And as you're going to be interpreting a contract objectively, then the basic rule is that you're not going to have masses of evidence. So somebody can be appointed with the necessary expertise to come up with the answer to that quite quickly. Sometimes it can be application of a statutory provision to a particular situation, but that narrow legal issue.
Okay.